and our percentage together. Yeah. I'm happy to sponsor. Oh. Well, thank you.
All right, so everyone, let's get seated. We're ready to get started with our next panel. Very illustrious panel that we have, speaking about mental health issues within the juvenile and family law system. I'm going to introduce the speakers briefly, who will be talking to you, and I'm going to introduce them in the order in which they will be speaking. And I want you to know that I am only doing partial resumes and bios for you because the rest of it is in your materials. They all have great accomplishments, but if I read everything that they've all done, that's all we would get done. So I'm just going to tell you the highlights of their career and then look them up in your materials, and you can see all the other wonderful things that they do and involved with. Right next to me, and the first speaker will be Kamala Lannetti. Cami is the Virginia Beach Deputy City Attorney for Public Education and School Board Legal Counsel. She received her BA from the University of Hawaii at Manoa, her JD from the Washington College of Law at the American University, and her MPA from the Old Dominion University. Before joining the Virginia Beach City Attorney's Office, she served as a Norfolk Assistant City Attorney. Cami currently serves as the Special Olympics Area 2 Coordinator, supervising all of the Special Olympic programs on the South Side. Next will be Christianna Cunningham. Christianna is an Associate City Attorney for the City of Virginia Beach. She received her BA in Broadcasting from Arizona State University and a JD from St. Louis University School of Law. Prior to joining the Virginia Beach City Attorney's Office, Ms. Cunningham was an Associate Attorney at Tabbs Fletcher in Norfolk, and she's currently serving as the Chair of the Virginia Beach Bar Association JDR Committee and President-elect of the James Kent in a Court. And she has the position that I once held in the City Attorney's Office representing the Department of Social Services. So, anyway. Julie McConnell is with us as well. We're not seated in the order they're speaking. I'm reading in the order they're speaking. Julie McConnell currently serves as the Clinical Law Professor and Director of the Children's Defense Clinic at the University of Richmond School of Law. She earned her JD from the University of Richmond School of Law and her undergraduate degree from Agnes Scott Women's College. Before coming to the University of Richmond, Ms. McConnell served as a prosecutor in the Richmond and Commonwealth Attorney's Office and as an assistant public defender. She is currently serving as the co-chair for the Advisory Committee on Juvenile Delinquency and Prevention and was selected to serve on the Virginia Bar Association's Commission on the Needs of Children. And next to her is Leslee Tingle. Leslee Tingle serves as an assistant public defender for the City of Norfolk. She received her undergraduate degree from Old Dominion University in 2006. And I did have to throw in one fun thing. This is what she's best known for, I think. She paid for that, her undergraduate degree in part with a job with Chick-fil-A as the mascot. And you may have seen her as the cow in the 2005 Norfolk Christmas Parade. So I just think that's awesome. So that's the one thing I kept. You can read all the fun stuff about the other people, but I like that. And she earned her JD, I guess more importantly, from the University of Baltimore School of Law. And prior to becoming a criminal trial attorney, she worked in several private law firms. So thank you for leaving your other position and becoming associated with the law and helping with juvenile law. Finally, we have the Honorable Tanya Bullock. Judge Bullock currently serves as the presiding judge of the Virginia Beach Juvenile Domestic Relations District Court. She earned her undergraduate degree from North Carolina State University and received her JD from Regent University School of Law. She's one of ours. So, prior to serving as a judge, yes, give her a hand. Judge Bullock worked as a prosecutor in the Norfolk and Virginia Beach Commonwealth Attorney's Office and started her own law firm, Bullock & Cooper, with her identical twin sister, which as a judge was often challenging for me. When they would walk in the courtroom, I didn't know who was there. But I knew by which side of the courtroom they were standing on sometimes. Judge Bullock currently serves as a member of the Virginia Council of Juvenile and Domestic Relations District Court Judges, the treasurer of the Virginia Association of District Court Judges, and was appointed by the Chief Justice of the Virginia Supreme Court as a member of the Committee on District Courts. So that's our great panel, and like I said, they all have a lot of other accomplishments and accolades that you can read about, and that is in your materials. But I didn't want to take away from their time. Each panelist will have about 10 to 15 minutes to speak. If we have time at the end, we can take questions. If we get to 3:30 and everyone has not finished speaking yet, we will just not be able to take questions. But hopefully,
some of my time for
Pardon?
questions. I will yield time.
You'll yield time
for questions for this lovely panel.
Okay. Thank you.
Good afternoon. For those of you who are not familiar with me, I grew up north. I speak very quickly. I'm actually speaking in my slow tone, so you may need to wake up a little bit to stay up with me on some of this. I'm going to talk to you about some of the issues in public schools. I've been school board legal counsel for Virginia Beach City Public Schools for the past 19 years. Just to let you know, Virginia Beach City Public Schools is currently the 4th largest school division in Virginia. We have 68,000 children on there, 15,000 employees, so we have a very large organization. We spend a lot of our time doing that. We have 3 full-time attorneys assigned to the school board. About half of the time, about 3,000 or 4,000 hours a year, we spend dealing with student issues. The largest portion of that has to do with special education, what we call Section 504 issues. So this is a daily issue. In fact, this morning, if you look at the newspaper, you'll see we have an issue with the Virginia Department of Education having to do a systematic complaint with Virginia Beach Public Schools special education. I was in there dealing with crisis issues. This is a daily issue for us in there. Out of our 68,000 kids we have in Virginia Beach, we have about a little under 8,000 children that are identified for special education services. We have another 3,000 or 4,000 students who are identified for what we call Section 504 of the Rehabilitation Act. We refer to them as Section 504 students. So we have a very large portion of students that have some form of disability. We're fortunate in Virginia Beach. Virginia Beach has a lot of resources that other school divisions don't have. We can keep almost all of our students in our school division and service them. We service children that are functioning at an infant level. We actually drive buses to St. Mary's Infant Home here in Virginia Beach, which are your profoundly and severely disabled children. We bus them into school. We have students that come into us every day. We go all the way through very intelligent, what we call twice exceptional children that are both gifted and have disability services. In Virginia Beach, we are able to service all those children. So these are issues that we need to deal with. Part of the reason you need to know at school starts is a lot of services are at school, a lot of identification comes in schools at a very young age. Under the federal law that deals with some of these issues, we go down as young as 2 years old. We have to identify students, and we go all the way through age 22. So most children, if they're going to receive their first mental health services, are going to be through us in the school division. Just some of the issues that we deal with in schools on every day. Students with emotional disturbance, which is one of our smaller categories of special ed. Our largest category of special ed has to do with what we call specific learning disabilities. It's dyslexia, dysgraphia, dyscalculia type of things. Those are about 70% of the students. Less than 2% of our students have emotional disturbance. But there's a high correlation with students with emotional disturbance and some of the issues that we see in schools, including with emotional disturbance, higher dropout rates, graduation rates. We see that consistently. That's an ongoing problem in that area. Disciplinary actions, and there are high level of our disciplinary actions with our special ed students come through students with emotional disabilities. Again, less than 1% to 1 to 2% of our population is what we would call the emotionally disturbed population. Other issues that we have, and we're seeing this more and more in a school setting, is suicide. Suicide is an issue, national issue. I'm sure you spoke today about lawyer wellness. It is a constant issue for us in schools. We see this constantly. We had last year at Salem High School, we had a student who had very severe mental health issues, who had been in a psychiatric facility the night before. His parents took him out, brought him to school, dropped him off without notice to school. He walked in the front door, went in the bathroom, and shot himself with a gun in the bathroom. These are issues that we deal with. We do have suicides on a regular basis. We have, when that particular student committed suicide, we brought in our school psychologist to talk to them. We had over 120 students come down and talk to the school psychologist about considering suicide themselves just in that high school alone. So this is an issue we deal with on a nationwide basis. We're seeing more and more of this. It's becoming a reality for us in schools having to address that. We also see the trauma issues that we have. If you're not familiar with what schools are one of the most highly regulated industries out there. There are so many laws that apply to schools that come in, including those are some of the homeless issues. We are subject to the federal McKinney-Vento Act. We have to deal with homelessness in students. We identify students with homelessness. We help them with services for housing in there. We also have to deal with hunger. We feed a vast majority of our students. About 60% of our students receive free and reduced lunch of some sort on there. We also provide in Virginia Beach services during the summer, during breaks. You'll come in. We also send food home on the weekends. We have a very large program called Beach Bags. Any child identified needing services will go home with a bag of groceries, so we make sure they have food on the weekends. In this particular area in Virginia Beach, we have a lot of military, so we have a lot of transient folks. We also, Virginia Beach is known as the runaway capital on the East Coast. So we will see a lot of runaway teenagers that show up here in Virginia Beach when they come into some of our programs in housing. Depression, substance abuse, also risky behaviors and things we're dealing with. Abuse and neglect, I'll let Christy talk to you about that a little bit more. Bullying. I don't know how often you see this. There is not a single case I handle that does not have the word bullying showing up in it. It is a very difficult, complicated issue for us to deal with. The Virginia Department of Education has a specific definition for bullying, which is a repeated pattern of bullying with the intention of harming somebody, but that's not how it's used with families. The families and students say to us, anytime things don't go their way, they say bullying, and we're expected to deal with that. A lot of the suicide we're seeing is also tied to bullying, so schools are having to deal with the bullying issues, the effects that it's having on mental health on a school basis. For those of you not familiar with the law, for those of you who think about special education, you probably think about IDA. In the 1970s, the federal government put through a statute called the Education for All Handicapped Children, EAHA, referred to. At that time, they were looking at students that were not being allowed to come to school. We were looking primarily at blind students, hearing impaired students, really predominantly disabled students, also students with Down syndrome. At that time, they were estimating about 10 million students around the country would not be allowed into school. So the EAHA came in with the intent that the federal government would help fund and get programs in for that. That has since grown over the years. You now know it as IDA, Individual with Disabilities Education Act on there. That's where special education comes from. That's the term for special education there. Under the IDA, you need to fit into one of 13 categories that they have, and there are very specific rules on those categories on there. But you not just having a disability, you have to have a disability, you also need what we call specially designed instruction. So you could have a disability, you may have an orthopedic impairment, you're missing a leg, you're in a wheelchair, but it doesn't affect your ability to be educated, then you may not qualify for special education services. Again, you follow a very specific regulatory procedure that has to have on that. The biggest concept you see in special education is something called a free and appropriate education. We call it FAPE. If you're a student in there with a disability, you're entitled to these services on there. You have the opportunity to come to school and receive services similar, not exact, but similar to students who are non-disabled on there. The term IEP, Individualized Education Plan, that comes out of this particular act that's an IEP. It's individualized, it's intended for the specific student to meet the needs of the student. That becomes the agreement the school division has with your child, and that's how we deliver services. They are individual. And again, 8,000 students in Virginia Beach, every single one of them has to have an IEP. Every single year that IEP has to be reviewed. Again, we're looking for specially designed instruction. What do we need to do to help you, to assist you get the education you need? More interesting for a lot of people, there's an assumption that because you have a disability and you're acting up that we may be throwing you out of school. There's a procedure that we have to follow. If you are qualified either under IDA for special education or what we call Section 504, which is a more generalized Civil Rights Act, we cannot discipline you for more than 10 days out of school in a school year unless we go through a procedure called a manifestation determination review. If you're a student that could, let's say you made a threat, a bomb threat at school at this point, we would come to the team, we would say, this child made a bomb threat to bomb the school on here, but we look at your disability, and your disability is dysgraphia. You have a hard time writing. They may say at that point, well, dysgraphia isn't really contributing to why you made the bomb threat at school. But if you're OHI, which is other health impaired, and you have ADHD, you were impulsive and you did it, or you're emotionally disturbed and you're having psychosis, that probably did contribute to it. In which case, if it is a manifestation of your disability that we have you documented under, we cannot discipline you, we cannot put you out of school. We need to reevaluate you, we need to come up with a plan for you so we don't put students out. And we go through this particular procedure. Again, we have a big concept, both IDA and Section 504 has child find. We are required as the local school division to locate all the children from ages 2 to 22 years old and determine whether you have a need of services. So we have a program we have to go out in the community. You will see us out there a lot. Some of the departments that Christy represents also goes out. We go out to look for students. We talk to the pediatricians. We talk to the hospitals. We talk to the social workers. If you are a student that needs a disability, you have a disability, or you're starting to fall behind, we need to go out and identify you. We actually have school buses that will go to homes and pick up 2-year-olds and bring them in for services. A lot of speech services coming in there. Anyone can refer them. It is also a responsibility of the school division to go out and identify you. If you're in a private school, we also have to go out and identify you. Again, we're looking for what services we can provide for you. We have to do a lot of evaluations and identifications that have to do that. There are all kinds of due process procedures. Special education is probably one of the most complicated administrative law procedures you're going to have. It takes a long time for a lawyer to learn to do that. Side note, if you ever want to get into it, there's a desperate need in this area for people to help parents learn to manage the system. It's very, very complicated, and we see that a lot. Unfortunately, I will say in this area what we're seeing is a lack of attorneys understanding how to do this procedure, and they're allowing other parents to go out and represent it. And again, when a procedure is this complicated with rights for students with disabilities, probably not the best thing to have another parent out there explaining. So if you ever want to know about it, or you want to venture in this area, come talk to me, because we certainly need that in this area. Again, eligibility for this, if you're found eligible for special education services, it refers to a team on there. An individual team is assigned to every single school. They average between 5 to 17 people on a team. So every time we meet with a child, all those people come around the table. It's a combination of the parents. It can be the child if it's an older child. It would be nurses, doctors, assistant principals, speech therapists, school psychologists. A lot of people sit down and create these plans to work with them. If your child is already being serviced by other agencies, are not uncommon for foster children or children doing with community services boards to come in. Those folks will sit on our boards and work with us. We're designing a program that assists this child in getting the services they need to develop out there. What's also interesting about the IDA and Section 504 is they provide protections against discrimination. So you may not need services, but you're also protected in the school division if you need something. So you can file multiple versions of complaints at both the state and federal level and at the local level if you think you're being discriminated against by your disability. And as I mentioned, there's disciplinary protections for you. We can discipline students with disabilities if they clear the manifestation determination process. If it is not a manifestation of your disability, we can go ahead and discipline you, but the vast majority of students, we do find it is a manifestation and we don't end up going through the disciplinary process with them. Once you clear that particular process, there are very complicated due process procedures that you have where we bring in hearing officers. For those of you ever done one of these cases, they typically are 7 to 8 day hearings with hearing officers. It's typically 2,000 to 3,000 documents come in, 40, 50 witnesses. They're very, very complicated hearings. They can go both to state and federal court. We have a couple cases currently going to federal court on very complicated litigation involved. Yeah, I mentioned the MDR process. The MDR process is built by federal law. This is to protect students with disabilities so that we're going back. The whole goal for a manifestation termination is if we are not providing the services or your disability is contributing to it, although it looks disciplinary in nature, the idea is to refer you back for evaluation purposes, to get you back to a team, get the services to you, and see what we can do to get you back into the education system. Educational placements are one of the more complicated things. We have a basic hierarchy on there. I think we mentioned least restrictive environment you heard before in one of the other speakers. That's a concept we have. The goal is to keep a child with disabilities in a regular classroom with typically developing peers as long as possible. And the vast majority, 70–75% of our students are in a regular classroom receiving some type of services on there. If you can't stay all day long, you need specialized services, you need a little bit more help with math, reading, speech, you might go into a partial day program. That's what we call level 2 services in Virginia Beach. You would go part of your day. You would go to regular English class, you might go to social studies class, but instead of taking chorus, you might go over to work with a special education teacher and help on that. If we have to, we will put you in a full day special education class. We have students that need that. There are specialized classes for that. That we actually, Virginia Beach, are fortunate enough to work with other programs like CSEP, a regional program. We have very specialized programs. If you're emotionally disturbed, you can go into a class when we have school psychologists working with you all day long on this. We have a large program for that. That's called the STEP program. We have a large program for students who are very limited intellectually and also have violent behaviors. We run that out of the Renaissance Academy. You can go over there, we train you, and then we work in some of those. Sometimes you might be all day in what we call cross-categorical. You have multiple disabilities on there. You're still in a regular school with other students, but you're in a classroom designed specifically to deal with your needs. If we cannot place you in somewhere in one of our school divisions, we can put you in an outside facility. And if we have at state level, you've heard some of the larger facilities we have. Grafton was long-term known for students with severe disabilities. Sometimes in psychiatric facilities, we have to put you over there. We do have to pay for that. If we put you in a facility like that, the school division is going to have to pay for that. A student who is placed in a psychiatric facility, long-term residential, it can be $100,000, $120,000 a year. Even Grafton's on that lab. Locally, we have a couple facilities, but there are also schools that are not full residential facilities. There are day programs. Chesapeake Bay Academy in this area is certified to take special education students. Orion Academy. We have some couple of specialties areas that have to do with autism, and there are students on the autism behavior. We sometimes pay for students to be in those facilities because we cannot manage them in our classrooms on there. Sometimes we go to court case and the family argues. This is not unusual. This is a very large area of special education litigation. Is I want to put my child at this facility because I don't think Virginia Beach City Public Schools can do it. They'll take us to court and the court will order us. And then we are stuck then until the family removes the child. We have to keep the child in that facility. An area like Chesapeake Bay Academy, you're talking $28,000 a year we'd be paying for a student to be there. And then home-based or homebound. Home-based is a disciplinary process that the Virginia Department of Education has. Let's say you did something too violent to be in school, we might send a tutor to your home. Homebound means you're too sick. you might have a disability. A lot of our students with chronic illnesses like cancer, something that cannot come to school, we have them at home, we bring tutors into them. We're fortunate enough with all our students in Virginia Beach now functioning on Chromebooks, we can get a lot of the students in with the electronic thing on there. But again, the hierarchy is there to keep the child in as long as possible. And again, because we have so many services, we don't end up having to put students out. Most students will be educated in Virginia Beach. Again, I mentioned free and appropriate public education. The major case in this particular area is the Raleigh case of 1982. Raleigh basically stood for what type of services do you owe a special education student. The Supreme Court said at that point, de minimis services, you just have to give them enough services to access the school division. And that's been the standard up until about 2 years ago until the NRF case came out. It's really not a whole lot of services. And I can tell you in Virginia Beach, we don't give you the basic services. Our special education students and our 504 students get a considerable amount of services on there. This area of law is constantly challenged. Parents will come in and say, I want you to maximize my child's potential. Maximize a child's potential is not something we do anywhere in the school division. I don't maximize gifted kids' potentials. We give you the opportunity to do that. But a lot of parents expect that we are going to correct your child's condition. And that's one of the biggest areas I think we have to look at in schools in there. I often have a parent come in and they're assuming that if we've identified your child for a disability, that it is our responsibility to correct that. School division's responsibility is to allow your child to access an educational system. And this becomes a large bone of contention with a lot of parents out there. And the way I explain it best to parents, if your child had cancer, if you came into us, and you told me my child's going through cancer treatment, well, we might modify the homework, we might send a tutor to your house, we may give you less work if you're tired, we'd be more than happy to give you your medication at school, we've got nurses there. What we wouldn't do is we wouldn't provide you radiation, we wouldn't provide you chemo, we wouldn't pay for your surgery. That's not the responsibility of the school division. That's an easy way for me to explain that to parents, but a lot of times parents assume that our job is to educate is more than educate your child, is to correct and overcome the deficiencies on there. And that becomes an issue. We have a lot of parents get upset about that, is what is our responsibility. If you have a child with a disability who's in public school, we will provide the services. We have a lot of services in the school division we can provide you, but it's still your responsibility to take your child to the doctor, to get your services, to get your family therapy. That still reminds your responsibility as a parent. Andrew F., the case came out in 2017. I mean, a major issue right now, if you open up your newspaper, you'll see a reference to a Virginia Department of Education systematic complaint that came down, and they cite throughout this particular 35-page complaint the Andrew F.'s case. When this case came down in 2017, the question was, what do you owe this? In this particular case, the parents wanted the school division to pay for private school for their student because they didn't believe the child was getting the level of services that they thought was appropriate for the student. And the school division said, no, we are meeting the Raleigh standard, the de minimis standard on there. What the court came down and said, and this has become an ongoing area of contention for all schools right now, is it's got to be more than de minimis. It can't be the minimum, it's a little bit more. But they never define what you mean by a little bit more. As far as the Council of School Attorneys in Virginia is, we said, well, it's just a little bit more. It doesn't have to be basic level. Parents think that means you maximize it. So we are right now in a position in Virginia and actually throughout the country, we're not quite sure what the Supreme Court is telling us to do with students. We think we're doing it appropriately, but we don't know, and that's a major area of litigation for us. I mentioned Section 504 of the Rehabilitation Act. Section 504 of the Rehabilitation Act is actually, the precursor to the Americans with Disabilities Act. It didn't go away after the Americans with Disabilities Act, but if you look at the language, it's very similar. Section 504 deals with particularly access to public education. This is actually a civil rights statute. IDA, special education, is a federal funding statute. It is not civil rights. It is how the federal government imposes its rules and regulations on localities. If you accept the money for federal government, which most school divisions do, and it's a very significant portion of most school divisions' budgets, about 40% or more of it on there, then you must follow the regulation the federal government puts. But that's not a civil rights statute. Section 504 is a civil rights statute. It's very similar to the Americans with Disabilities Act on there, but it really was generally protecting students with disabilities. You might be a student that does not qualify under IDA for special education. You might then be able to qualify under Section 504. It also allows us, if you feel like you're being discriminated against, most people will use Section 504 on that. The difference with Section 504 is we don't provide specially designed instruction. We provide accommodations. That was what it was originally intended for. If you needed the elevator to go to the second floor on there, if you needed a handicap bus in there, if you needed special readers because you couldn't turn the pages on your book, that's what it was intended. However, over time, the U.S. Department of Education has expanded it. It looks very similar to IDA. The procedures are very similar. It's very complicated on there. It's actually easier for the federal government to find a violation under Section 504, so they tend to use Section 504 a lot, but it's a generalized special education regulation. And it really provides non-discrimination protections for students. It is a vastly growing area for us to deal with. It is by far the largest area the U.S. Department of Education will find regulation for. It has a complaint process on there. If you have a concern about disabilities in there, you can both go to the U.S. Department of Education. I know these people, I spend almost every day dealing with complaints up there. Virginia Department of Education also has regulations for them. So again, there's many procedures school divisions have to follow when they're dealing with these students. Very common for a family to file a violation, particularly if they don't agree with something. They don't necessarily have to go through the due process. They can go through the complaint process, and they're also subject to school divisions to regulations. One of the other areas that we've had that's been growing the last couple of years, you will see with the Virginia school threat assessment areas. School violence is a major issue since Columbine. We have completely redone how we do things in school divisions. Columbine, of course, was one of the worst school shootings we had, but school shootings are actually pretty common. A typical year in the United States, you'll see about 100, 120 different shootings for this. What we are seeing for this big area is the need for us as a school division to start monitoring them. And what came out from the General Assembly was the threat assessments. Anytime we have a threat made, we have to assemble a team of knowledgeable experts on there, and we need to address this. Initially, it just dealt with students. It's now gone to staff. It's gone to family members, anybody in the community. Because as you'll see in a school shooting, what happens for us is there are copycat crimes. So as soon as one person makes a complaint, we will see that. I think last week we had 4 threats alone in Virginia Beach. It's a very difficult area for us on there. Originally, I said we were looking at students. Amazing, a lot of the students that we see that make the threats are not students that are currently identified for special education services. So it gets complicated for us to deal with that area. But additionally, what we see is because there's so much public attention given to school threats, and it constantly gets in the news, that other people come to schools. They may not be school related, but they know if you come to a school and cause it, you're going to get the media attention that you want. There's a subculture, if you'll see on social media, having to do with school shootings. So we now have to deal not only with our students, staff, family members, or members of the community, and there's a complicated process that we go through. And again, this particular team involves just not school people, it involves police, it involves social services. A lot of local governments have to deal with that. School counseling programs, we've recognized with time that the school is the first place a lot of students are going to learn some of the disciplinary self-regulations procedure there. We have very complex programs having to do with suicide, prevention programs, talking to students about their needs to deal with their mental health issues on there. School-wide programs you'll see in Virginia is what they call the PBIS system, the Positive Intervention System. These are actually a whole school theory. We're going to teach the kids starting as young as kindergarten how to regulate yourself in school, how to deal with people, how to appropriately mediate programs. This year in Virginia Beach, we finally reached the point where all 85 schools are on this particular program. We're hoping that long-term these programs will then teach children how to regulate themselves when they go out into the community, how to mediate problems on there. We talk a lot about responsive classrooms. We're teaching our staff members, not just our teachers, but all our staff members to recognize when you're seeing a student, is the student isolated, is the student acting out? How do we respond to the student on there so we can get in there earlier in schools and get those students referred to the services that they need? At this point, what I will tell you, if you're looking at school division services, if you have an opportunity to do family law, criminal law, please talk with your school division. We do a lot with students in there. We have very complex webs of services that we plan. We work interagency on there, and I'm sure Christy will talk to you about it. These are very, very difficult areas for us. We are on the front line of trying to solve some of these problems, identifying these students and these families. What we find very much in local government is that families come to schools. We are the center of communities. Most communities, your elementary schools can be the center area. Families don't come to us just when they're special ed. They come to us when they have problems. So we're realizing we're the front line of this, but we don't necessarily have the ability to solve all the problems. So then we end up having to work with other organizations in the communities. If you'd like to know more about it, please feel free to contact me at this time. But again, if you're dealing with a juvenile or family that has issues, please talk with the school division. There are a lot of services. We can get you connected into those services. We can connect you with the different agencies that can help you out, and that is part of the responsibility of the schools. This time we'll turn it on to Christy, who takes the rest of the community services.
All right, well, I get to be the redheaded stepchild in the room because I represent the Department of Human Services. And in Virginia Beach, that means something very special, which we'll go on and explain. But first and foremost, what I'm here to talk to you today a little bit about is some terms of art that we are using in the world of human services, social services. And it's not just with our children, even though this panel is dedicated to juveniles. It's also in the adult world of mental health. And that's called prevention. Cammie talked about the threats that we are seeing with our schools. We talked about earlier today, the panels this morning, about mental health and how that affects people in the jails. We heard about how the jails are becoming the largest population of, or basically psychiatric institutions in place of what used to be asylums. Well, today we have situations where we have to get on the front end of it. And now oftentimes when you all think of the word, I don't know, DSS or the Department of Human Services, Social Services, Child Protective Services, Adult Protective Services, you think of somebody, I don't know, hitting their child. Somebody, unfortunately, sexually molesting their child. That's usually what comes to people's mind when you start talking about Child Protective Services and talking about the removal of children from their family because of abuse, because of neglect, whether it be because of some affirmative act like physical child abuse or because of a parent of inadequate supervision, domestic violence, substance abuse, all of the above. Well, 90% of the time in those abuse and neglect cases, what we find out is that there's a huge mental health component, not just with the kids, but with the parents and the grandparents and the great-grandparents. It's systemic. And so that is one of the main issues that we are now dealing with on the front lines of Child Protective Services, is getting at the head of the issue, the root of the issue, so that we can stop the self-medication, stop the abuse, and stop the neglect on the front lines, and that's prevention. Abuse and neglect is not the only reason also that children are now separated from their parents. You heard earlier today that some families, I think Judge Migliosi talked about his colleague in England, that are faced with the unfortunate circumstances to have a child whose severe mental illness or behavioral illness is such that their behaviors prohibit them from staying safely in the family. You're a parent who loves your child, and all of a sudden you can't safely keep them at home because of their own behavior. Not because of anything you're doing to them. You're being a perfect parent, as perfect as you can be. You've taken them to the doctor, they're medicated, or they're going to therapy, but it is just impossible. All of a sudden, you're faced with a situation of self-preservation versus family preservation. And that is becoming one of the biggest segments of cases that we are seeing in my office. Now, the Virginia Code has a designation for these types of cases, but it's kind of an old-fashioned term. If anybody has ever heard of the word CHINS, in my world we deal a lot with alphabet soup, acronyms. CHINS stands for a child in need of services. And unfortunately, that word CHINS has this connotation of this kid who is on the borderline between a criminal and just a really bad, bratty kid who doesn't want to mind. But it's the only vehicle sometimes that people have to get help. And that's the key, is that shouldn't be. You shouldn't have to knock on Judge Bullock's door to get help with a child like that. There should be another way to get assistance with a child who may not be safe in the home, because that is the growing number of cases that we are seeing where you have parents, or sometimes it's grandparents who have become the parents, knocking on our door and filing things like CHINS or what's called a petition for relief of custody, saying, please take my child. And unfortunately, it all has to do with two specific populations. It has to do with the mental health side of things, and it has to do with what I'm going to call a behavioral disorder. We're seeing more and more children that are diagnosed on the spectrum, whether it be some pervasive disorder. You've heard the word autism. You used to hear the word Asperger's. But there are all of these disorders that we are calling on the spectrum that are not necessarily mental illness under the DSM-5. So you have these two populations of kiddos, and they may or may not be able to be treated with medication, and they may or may not be able to be treated with conventional therapy, and they may or may not have co-occurring diagnoses. The younger kids may have a whole host of other issues, ADHD, reactive detachment disorder, and again, it's alphabet soup. Or, especially when you get to the older kiddos, and I'm going to use that term a lot because I think that that's just gotten into my terminology for the past 20 years, you see them self-medicating because they have never been brought properly before a service provider to get straight. Not because anybody did anything wrong to them, but because nobody knew what to do. And of course, then there are the systematic failures of the family, where the family members themselves have the same issues that have never been recognized and never diagnosed. So why, if he's acting just like I acted at that age, why would I think that there's any problem? He's just being a kid. And that's true. Teenagers can be teenagers, and you know, our brains aren't really developed until we're 25, and so there's a lot out there. But then there are those kids, and you all know them. Whether or not they fit in those definitions, they may need a specific set of help, and it's really hard to find that help. So that's where my client comes in, the Department of Human Services. So you've got a couple of tracks in order to kind of open that door up. But one thing I did want to point out was that in all of these cases, what we're trying to do is preserve the family unit. We're trying to make sure that we have done everything possible on our end to avoid a separation, and that's the new term for removal. Every year we create new terms to try to make it sound better, but that's what it's called now, is we try to do everything possible to avoid separation. Well, all right, let's talk about how we do that. First of all, a long time ago, actually not a long time ago, but when I first started working in the area of the Department of Human Services and Child Protective Services back in the age-old ripe age of 2004, it was a very different era, very different feeling in the world of social services. And when I say that, I mean that social workers and the families that they dealt with each other were dealing with each other at arm's length. There was this weird fear that foster parents and biological parents shouldn't know who they were, that you shouldn't know anything about each other. There was this real fear that you had to be in foster care to get the type of services that foster care provides. There was a real misunderstanding of just all these terms of art and what the municipalities could fund with foster care dollars under what was then called the Comprehensive Services Act. It's now called the Children's Services Act. What you could now fund if the child was either in care or not in care or at risk, and all these terms. And all the municipalities across the state were dealing with it in a little bit different way, to the point where somebody finally had to knock on the door of the Attorney General in 2006 and say, help. And it wasn't until this 2006 Attorney General opinion that we all woke up and went, oh, you don't have to be in care to get foster care services. And oh, the municipality can pay for that type of service even though you're not in care. So the Asperger's child, or the bipolar child, the out of control child, we can use all of those really heavy services that we would use in a therapeutic foster sense that cost a lot of money. We can do that without having custody of that child, and we can pay for it. And all of a sudden, that opened up a whole new world. And all of a sudden, there was this concept of what's called family engagement that was spreading across the nation. And unfortunately, I have to concede that Virginia was one of the last to catch on to family engagement. Family engagement means now foster mom, biological mom, whether you're in abuse or neglect context or whether you're in a mental health chins-like case, nice to meet you. Let's work together. What information can you provide to me trying to put families in the driver's seat of their own destiny, because what my family may think is right for us may not be what your family thinks is right for us. So let's come to the table, whether it be because we're trying to help a mom get out of a bad situation, domestic violence, substance abuse. Let's put it towards, let's try to build you up instead of putting this big rubber stamp on you that you're an abuser and neglector. We may have to make that finding that the child has been abused or neglected, but that doesn't mean that we can't just say, okay, let's move on from there. Let's start from scratch. We've met each other. We know what the circumstances is. How can we remedy it fast as we can? Same thing with the kids in the mental health situation. How can we front load these services to get the family wrapped around with as many support services that we need before we think about separating that child from the family? Because what we know now is that there are these things out there, and if you all have heard about the 1995 to 1997 Kaiser Permanente study on adverse childhood experiences, if you've ever heard these ACE scores, again, here we go with the acronyms, what we know is that as you progress through childhood, the more checks on this adverse childhood experiences scores checklist, the more developmental issues you're going to have, the more trouble you're going to have later in life. So if we can stop that, if we can stop that number from getting any higher, right, nip it in the bud, then that child's going to be successful. So that goes into preservation and prevention. And that's really what the key to the current state of child welfare is right now. There is a lot on this topic. There are two other key things I really want to hit. And one of those is just to make sure that everybody who doesn't practice in Virginia knows how unique we are. Because in a lot of states, social services is completely controlled by the state. It is the state that has the custody of the children. It is the state that governs the policies and laws and procedures. Well, yes, the Code of Virginia does all of that. But the way we're set up, it's the municipalities, it's the counties that actually take custody of the kids in foster care. All right, so it's a municipality-driven program. Social services are locally administered. So I have close to, I think we've got 200 and some odd kids in foster care held in custody by the city of Virginia Beach right now. I don't want to know what Norfolk's number is, but it's it's not the state, it's the cities. And I think that that's really key to a lot of people understanding our system. The other thing is this notion of a community services board that does all the mental health. Under the Virginia Code, a municipality has to provide mental health and behavioral health services. And that can be done by one of two entities. A community services board is the majority of ways that it's done throughout the Commonwealth, except in Virginia Beach, which it always gets us into a little bit of trouble. We have our own behavioral health unit underneath the Department of Human Services. So if you're ever looking and want to send a letter to the Community Services Board, please don't. We have an advisory board, but we don't have an operating CSB. Please send it to DHS. The last little bit I want to get into, because I see my time is running up, has to do with the current hot topics in child welfare and prevention. And those two things, which everybody knows about right now, one has got to be easy. It's the opioid crisis, right? All right, Virginia Beach just joined on to the class action lawsuit against the opioid manufacturers. So we're joining in the charge, but we are dealing with that in a new way. I don't know if anybody realizes, but as of July 1, the Virginia legislature changed portions of 63.2 of the Virginia Code to bring us in line with the federal litigation and federal laws on the opioid crisis, which basically provides that when we have these new kiddos that are born substance exposed, we have to develop a safe plan with the hospitals. We have to come up with a parenting capacity evaluation with the hospitals. So it's really more of a hands-on approach to dealing with substance-exposed infants. And that is a new and emerging area, so be patient with us. The last thing I'll mention is unfortunately, I wish I had more time because it is my current passion issue. It is the issue of our kiddos on the spectrum, because they do not fit, they are square pegs in round holes. Magistrates don't want to TDO them, ECO them. There is no place to put them. And I'm not advocating that they be TDO'd, by the way, but there is no place for an out-of-control teen that can't be controlled by medicine and therapy. And there's no place for him. So what happens when you have a young adult who just turned 18, he's severely on the spectrum, okay, and he's deemed incapacitated, meaning he can't give informed consent or contract or do anything like that, be an adult in the real world, he can't hire a lawyer, so you gotta get him a guardian and conservator. And then he's charged with a crime. And he's found competent to stand trial. But then he's found insane at the time of the offense because of his impulse control. What do you do as a judge? He's too risky to let out into the community, but I have to let him out in the community because of what he's charged with. The Commonwealth has to null pros the charge on a misdemeanor. It is the biggest issue right now that we're facing in the courts, is what to do with these kiddos that don't fit within that box of mental illness, but they fit as a result of their symptomology outside of the code. So that's just a little bit to chew on, but if you ever have any questions about how Virginia Beach operates, whether it be on the adult side of things or on the kid side of things with the Department of Human Services, I'm at Cammie's office and I'm available.
Thank you, Christianna. I feel like you really set me up well for what I want to talk about. One of the things that I've seen ever since I started practicing in juvenile court is that families are desperate for help by the time they get to juvenile court. They have not been able to find those prevention services in the community, and the first time they've had anyone actually listen to them is often when they come to the juvenile court. So they're desperate, and they're hoping that the juvenile court can solve all their problems, but unfortunately, the court doesn't have the resources always to address so many of these issues as you've heard today. But the great news is that with kids, first of all, the population of kids getting in trouble has decreased dramatically, which I'll show you later on in my presentation. So we actually have a golden opportunity to do something here. But the problem is we don't always know what the answer is. And it's not just the spectrum disorder kids, it's all kids who have suffered severe trauma, who have suffered poverty and abandonment in their homes, and have all kinds of issues that are so complex and need incredible intervention that the court doesn't always have the time or the resources to address. Oftentimes they try things and they're just not effective. And there are long waits for those programs, there's not funding for those programs, but we keep trying over and over again to do something because we all care about these kids. Everybody that's working in the juvenile court, all the people that you're hearing from today, we're here because we love kids and we want to help them. But there are so few options in the current system that we have. And because there really is no safety net, parents come to the court out of desperation. And the first thing they often hear from the court service unit when they file that chins that you heard about is the only way you're going to get real help is to actually file a delinquency petition, not just a chins. And so if the child has damaged property in the home or something along those lines, they'll charge them with that delinquency because they believe that the court's going to be able to provide an answer. But unfortunately, over and over again, they find that that doesn't happen. There's very little oversight for the programs that we have in our communities. We try in-home counseling with every child I've ever represented in juvenile court. The first line of defense is always, we'll try in-home counseling. And in theory, that sounds like it should really help. But what I've found is a lot of times those mental health counselors actually aren't mental health counselors. They have no training in mental health. They have no credentials whatsoever in terms of understanding trauma or the disorders that these kids have or the complex problems that these families have. And they may help with things like getting to appointments and making sure you remember to go to court and that sort of thing, but they don't necessarily address the fundamental problems that exist in the family. They don't provide group counseling, they don't provide grief counseling, but we hope that they will, and so we keep trying that over and over again. And one of the biggest problems is there's really no system in place for checks and balances to make sure that if the in-home counselor isn't effective, that we're going to try something else. And so what happens is when we come back to court, oftentimes the behavior that got the child in court in the first place hasn't changed. And so we wonder why. And usually it's because the services that we've tried to provide really didn't address the behavior in the first place. But we keep trying. But one of the things I want you to really think about is that the ACEs study that was mentioned earlier, it told us that so many of these kids are experiencing extreme trauma in their childhood and that it has a lifetime impact on them. But what we have done over and over again is we've decided that they have a conduct disorder, or they have a mood disorder, or they have ADHD, or some other disorder that we can prescribe medication for, rather than an understanding that the behavior is actually a natural response to the trauma that they've suffered. I see some folks nodding their heads. I know you see this with your cases as well. And so we know, as the attorneys that are representing those kids, that if folks would recognize that this is actually an appropriate response to what they've experienced, and that we need to have evidence-based responses to put in place, that we could actually intervene in a positive way. We could do that preventive care that we've talked about. But unfortunately, there aren't enough of those evidence-based responses available in most of the court systems, at least the ones in which I practice. And I see over and over again that we keep asking for evidence-based responses and we don't have them. We don't even know what they are. We know wraparound services help. There are lots of studies that tell us that. Wraparound services are incredibly expensive. And what I've found over and over again is that courts are often reluctant, and DSS is often reluctant, to pay for those services until things get really extreme. So the kids just keep getting in trouble. And finally, when it gets to be serious enough, then we'll say, okay, we're going to do multisystemic therapy, MST, another alphabet soup. We'll throw everything we have at this family to try to help, but usually by then, it's gotten too out of control. So we need to find better responses that intervene earlier, and we need to be willing to pay for that MST from the very beginning when we see that this family is in crisis, but that's what we're often not willing to do. And because of that, we try medications. And more of the kids who are on Medicaid, or CHIP, as we have it in Virginia, are on medications for conduct disorders than kids that are going to through private health insurance, because that's the answer that is always given. Well, we'll try this drug, we'll try that drug. But the problem is those drugs have not been tested on children for good reasons. They're often very unsafe. And so we're experimenting with those kids when we give them the medications. And what I see is they often are administered improperly because parents don't really understand what it is that they're supposed to do with medications. They run out of money. They can't get back to the doctor to get the next. They're often controlled substances, so they can't get them until they go back to the doctor. They don't have the resources to do that. They don't have transportation. And so their kids are often abruptly removed from the drug in a way that can be very dangerous. Or they're mixing drugs, or they're taking them at the wrong time. I can't tell you how many of my clients are on multiple antipsychotics and anti-anxiety drugs, and then also on a very heavy dose of something to help them sleep at night, because the medications that they're on keep them so wired during the day that then they can't sleep at night. So we're taking them up and taking them down all day long. And often these drugs have really severe side effects when they don't taper off of them, but I see it every day in my practice that families don't understand that. They don't understand what the doctor's saying, and they don't know what to ask, and they often just do the best they can, which is really not good enough. And it's very hard for the court to monitor that and make sure that the medications are being administered properly, because they only get to see those kids every couple of months, right? But it's one of the reasons that kids come back to court so often is the court is desperately trying to supervise and intervene and provide some structure for these kids and do the best we can to respond. But there's so much that is happening outside of court that all of the folks in there who are trying to help don't necessarily have any control over. I have a child right now in my clinic at the University of Richmond who literally went to 7 elementary schools. And he is now in 6th grade and he's been to 2 middle schools. Can you imagine that chaos in your life? And how in the world would you make sure your child was getting the medications they needed when they are moving that often? And in fact, he actually went to more than 7 placements, 7 different schools, but 9 different placements because he kept going back to a couple of schools. So that kind of chaos and instability also adds to the trauma and the behavior that gets kids into court. And we're so desperate to do something that we put labels on the kids. We call them oppositional defiant, or we say they have a conduct disorder, or we say they're ADHD. And many of these kids truly are not benefiting from the medications for those drugs because that's not the right diagnosis for them. But those of us who are practicing in juvenile court are not doctors. We're not psychiatrists. We're doing the very best we can, but we're not the professionals who really could be making the right decisions about how to respond to these things. So one thing I think that would really help, and some jurisdictions have done this, is to add mental health treatment at the courthouse or at the school setting. There's an incredible movie that I hope you'll all watch if you haven't already, called Paper Tigers, which is about a school that is trauma-informed. They took the ACEs study and they said, what can we do to better respond to these kids? Now that we know what a huge impact it will have on them the rest of their lives, what will help? And there is incredible research that shows that if you support the family, if you build the family up, I think those were your words, you provide those protective factors that can keep that trauma from ruining that person's life. So there is hope, but we have to be willing to do what it takes to do that. And one of the ways, I think, is to have the services so available that people stumble over them. You know, they're right there in the courthouse, they're right there in the school. Mental health treatment, medical treatment, counseling, it's all right there. So you take away the stigma. People don't have to worry about, getting across town to the appointment. They don't have to worry about the fact that they've just lost Medicaid. I don't know if you realize this, but the population that we work with, these kids are on and off Medicaid every day. If you get held in detention, you get kicked off Medicaid. You have to reapply. If you get put in a different setting, you could be kicked off Medicaid as well. And so there are constant ups and downs for these families so that they can't even continue to get the medical care that they need. So they're living in a car, they're getting their kids to school, but that's about all they can do. And at the same time, they don't have health insurance. And so we need to take away those gaps in service. Their kids should always be covered once they're eligible for CHIP, for Medicaid, so that they can always get the help that they need. And we need to provide funding for the services that we know work, like MST, like family preservation. I'm happy to say we do have that in the areas where I practice as well. But so many kids can't get into these programs because they're sort of in and out of the hospital. They're going in for those 72-hour emergency stays in psychiatric hospitals. They're getting released. And then guess what? No one wants to take those kids in the programs that exist out there because they have issues with anger. They have issues with psychosis. They perhaps have acted out in some way based on their own abuse. They've acted out sexually against another child in a foster home or in a group home setting, and so then no one will take them. So those kids get bounced around too. Sometimes they even get sent out of the state because no one in Virginia, none of the group homes will take them. Because we don't have enough of them, and we don't have enough of the kind that are actually designed for therapeutic foster care. Transportation is probably the #1 biggest thing I see my clients face in terms of getting the help that they need, particularly in bigger jurisdictions like Virginia Beach, Chesterfield County, which is near where I primarily practice in Richmond. These are jurisdictions where there's very little transportation, very little ability to get around. There might be 2 Medicaid doctors in the whole county that provide services. You might live in the eastern part of the county, and the entire western side of the county is where all the doctors are, so that makes it really hard. And we're willing to fund programs in school for things like school resource officers. The Stop School Violence Act of 2018 added $75 million, if it gets passed, for school resource officers. A lot of people think school resource officers are the answer. And there are some good things that school resource officers bring to the table. But we don't provide that same funding, or any funding really, for mental health counseling in school. And so we could negate that problem of transportation if we were willing to put the money into providing true therapeutic resources in the school setting so kids would have it right there. They'd have it wouldn't take any effort to get the help that they need. The other thing is these medications that they're on, we have no idea what kind of long-term impacts they're going to have. They really do affect their behavior. So a lot of times I have kids in court for cases where, you know, they acted in a rage when a teacher tried to get them to give up their phone. We've all seen the South Carolina videotape, right, of the school resource officer. He's trying to get the young woman to put away her phone, and she doesn't want to. She just had gotten out of a very traumatic situation in foster care herself, but his response is to grab her and, you know, throw her on the floor because he just doesn't have the training. He doesn't know how else to respond. We should be making sure that everyone that works with kids has the training they need to respond to these very real problems and sometimes very real threats. But we don't. We don't train school resource officers in any kind of systematic way in Virginia. We have all kinds of different models about what the role of a school resource officer is. Sometimes they are disciplinarians, sometimes they're your best friend, sometimes they're there for protection. But they really shouldn't be in the role of discipline. That's really a responsibility of schools. And when it gets put in the lap of a police officer who's not trained to deal with these issues and doesn't know the history, has no idea that the child has an IEP or has any protections under Section 504, then they react in ways that further the trauma of that child. Schools have so much on their plate already, but being trauma-informed is better for everyone, and it is something that we absolutely have to be willing to put our resources behind. So behavioral health dockets have been talked a lot about today, and I think they're terrific, and we have a few of them in Richmond as well, and I'm glad to see that they're in other parts of the state, and I think they really can make a difference. The only thing I will say is that so few kids actually get into those programs on the juvenile side. Just a handful of kids usually are in the behavioral health docket. And I would say 95% of the kids I represent need the services of a therapeutic court like a behavioral health docket. So I hope that we will continue to expand them. But my only caveat would be, why shouldn't the entire juvenile and domestic relations court be a behavioral health docket? How about that? I mean, that's really what it's about, right? Thank you. That's really what it's about. I mean, we're there to try to help these kids not become the individuals that we heard about at lunch today, right? I mean, I started out in my work in the criminal justice system working with men on death row. And it was incredibly powerful and gratifying work. But I decided that I couldn't take it unless I figured out a way to work with a child and try to help them to not end up there and not create another victim. And that has been my life's work, and it's been so meaningful. But there is still so much more that we have to do. Because we often I see it every day in juvenile court, the kids age out, and we really haven't solved the problem. We really haven't intervened in a way that would truly prevent them from becoming that man on death row later in life. And we're missing a golden opportunity. And I was at a conference this past weekend, and I heard an incredible quote that was something along the lines of, just because what we do in juvenile and domestic relations court is confidential and we keep everything secret to protect kids, doesn't mean we have the right to fail them. And right now, we are failing kids on so many levels by not taking a more comprehensive approach. Everyone is trying really hard. I don't know a juvenile court judge, a juvenile court public defender, or a prosecutor, or a probation officer who isn't trying their best to help these families, but they just don't have the resources. So we as a community have to decide that we are ready to commit to not failing these kids. So thank you for your time. This is the fabulous slide I wanted to show you that shows how much juvenile intake has reduced from between 2008 to 2017. 64,000 cases down to 39,000 cases. We are not handling as many cases, so we have the time to do it right.
Thanks, Julie. Great presentation and good segue for my little segment. Does anybody or has anybody heard of Khalif Browder? Does anybody know about that case? I was at this same seminar with Julie this past weekend, and they reminded me about this incident with this 16-year-old child in New York who was accused of stealing a backpack, had some credit cards in it, some other stolen items. Thank you. He was held at Rikers Island for 3 years, 2 of those years in solitary confinement, got out, made some progress, and at 22 committed suicide. That is an extreme case, and thankfully in Virginia, I know certainly in Norfolk and Hampton Roads, we don't have that type of criminal wrongdoings happening. Virginia has made some good legislative initiatives to make sure that juveniles are protected. But I want that to be in the back of your mind as litigators in Hampton Roads and across Virginia, as well as new attorneys who are coming into the practice of law in juvenile court, because really the entire criminal process is trauma. We've kind of had this same theme going on. So just practical ways of trying to mitigate negative mental health impacts on juveniles when they come into the criminal justice system. That's what I'm going to be talking about. A lot of our resources and a lot of the things that we have going on aren't expansive enough and aren't perfect, but I want to let you know what we do have and what is working. When you first meet your client, you're going to have what I'd say really 3 types of clients. You're going to have clients who already have a mental health diagnosis. You are going to have clients who there is a suspicion that a juvenile has something going on, but it has not been diagnosed for various reasons. Family's not on Medicaid. They haven't reached out and gotten any type of screening for their child. And then also the third type, which may not have a mental health diagnosis, but the process and the touching of the criminal justice system is traumatic. And as we know, trauma can lead to mental health illness, depression, and so forth. So really we need to be thinking of our clients in those 3 different types of lenses. Immediately, you're doing some sort of triage. In Norfolk, we get our appointments for our clients immediately at arraignment in juvenile court. So we really have the ability to kind of talk to all the parties at the onset of the criminal process, talking to court services. They typically provide an expediter who is tracking and monitoring juvenile cases if they have not been on probation or have not touched the criminal justice system before. So we're able to talk to them, talking to the parents, talk to everybody as quickly and as fast as you can, because at arraignment, you need to make quick decisions about custody and trying to get them out of detention. And that's really the theme of my presentation today, is get them out of detention, get them home, and get them services. Again, we need to be looking at the children with a trauma lens, knowing that each contact that they have is traumatic. Here are some problems with detention. We've talked a little bit about it. People don't know, but when a child is out in the streets and they are arrested and the decision is made to detain them, they go through a strip search to get into the detention facility. For a 14 or a 15 or 16-year-old or any child and any person, arguably, that is traumatic, especially if you've never been involved in the criminal justice system before. You are separated from your family. The entire process is traumatic. In Norfolk, we do have children. It is better now that we're in the new courthouse, but we do have children being held in lockup facilities, that in cells next to adults being held in lockup facilities. You're hearing all kinds of adults, screaming and cussing, and it's scary. It's a scary place to be for a child. They're also shackled. They have shackles on their hands and their feet. Again, these are all traumatic things that are happening. We know that the more contacts, the more trauma. You have higher recidivism rates. You also have loss of continuity of services. If you have a client who's coming in who already has a mental health diagnosis, who already is getting family therapy, who's already, has a prescribing doctor, who has medication management, the loss of continuity of those services is a big deal. As Julie mentioned, Medicaid can be cut off if they are in detention. Also, there are mental health providers. If they have in-home services already, they will stop coming, and those services will get cut off after 30 days, after 60 days. So that is really important that you know those problems, which is another reason we need to be getting the kids out. I put this slide in here because tough in the streets, there's a lot of talk sometimes from adolescents, as you know, as I certainly remember from my youth with my own mother. We are talk and bravado and sometimes act real tough, but we are not that way as kids. There's a really great article in Mother Jones called Thousands of Girls Are Locked Up for Talking Back or Staying Out Late. I've put the link here to the article. It actually talks about a young woman in Virginia who mother was incarcerated, didn't know where dad was. She was adopted by her 70-year-old foster mom. As you can imagine, being a teenager and having a 70-year-old guardian, there was some supervision issues. There were abandonment issues. There was a lot of mental trauma that she had been going through, and she was a lot of talk and hard to handle. So she gets locked up, and she says, after the judge's sentence that day 12 years ago, she's, by the way, graduated from law school as of the time she wrote this article, an officer handcuffed her and drove her to a Hawking Concrete Detention Center where she had to undress and put on her uniform, underwear, a sweatsuit, and socks. I couldn't believe it at first, she says. It was so unreal. She spent most of that first day in tears. So just to remind, as new attorneys coming into juvenile court and as old attorneys who are still there, they are kids. So they are not as tough as they may seem. Detention reviews. So a lot of times, and Norfolk judges are really great about this. I don't know how it is in other jurisdictions, but the code actually requires an immediate detention hearing before a judge on the next day that the court sits. In Norfolk, that's at the arraignment. So 16.1-250 notates this. Most of the judges in Norfolk Juvenile Court do this. There are some substitute judges or retired judges who don't always abide by this. We get a lot of pushback from the Commonwealth attorneys sometimes if it's a serious offense or if it is, a situation by where they want to notify the victim. They want to treat it like an adult offense. If you have a new prosecutor or a prosecutor who hasn't been in juvenile court long, they ask for 2 days. That's their standard practice so that they can give the victims notice. Please notate this code and push for custody review at the arraignment. Back to my first slide, that's kind of the triage period that you have to talk to everybody to get a feel for what's going on so that you can advocate for your client to be released from detention, particularly if they have these services ongoing. We are looking for the least restrictive intervention. Least restrictive is kind of the idea and theme that I heard also from Ms. Cunningham in her department. But we're looking for options to get them out into group homes, advocating step downs to outreach, detention with or without GPS, or just release from custody to their parent. Modification of release, I put this in because sometimes I'll get a situation where I'll have a kid who is out of custody completely and he's not on outreach and he's not on GPS. And we'll have a Commonwealth attorney want to ask that they be put on outreach with GPS. This is an important code, 16.1-248.1. It says, if the intake officer or magistrate releases the juvenile, no motion to revoke bail or to change such conditions may be made unless, number one, they violated the condition somehow, or two, the attorney for the Commonwealth presents evidence that incomplete or incorrect information was relied on by the intake officer or the magistrate. So in this code section, it has a whole list of things that intake officers use to determine whether or not a child should be released, similar to the magistrate for adults. And if they've decided that the kid is out, if you have a Commonwealth attorney who is trying to add on the condition, or sometimes judges maybe sua sponte do it, push back on that. Use this code section to push back on that. This reads to me that there is a presumption that the decision was correct. And so we need, if we have a Commonwealth attorney asking to move forward with additional requirements for detention like outreach or GPS, the burden really is on them to show that the intake officer didn't have all the information. Simply having the parent there adding some concerns about curfew or the probation officer there adding concerns about curfew isn't sufficient. And so push back on that, ask for a hearing, and put that burden on the Commonwealth attorney. Services at detention. So Jennifer Reckelmay, Jennifer, she's here. I apologize for mutilating that last name, but she is the point person at the Norfolk Detention Home. She is basically everything at the Norfolk Detention Home. When I spoke with the detention superintendent, Mr. Bell, and asked him what predispositional mental health services were available, his answer was none. So detention is really not the place for kids with mental health illnesses and so forth. So Jennifer can be a good contact. So if you end up practicing in Norfolk, or if you end up with a child in Norfolk Detention Home, even if you practice in other jurisdictions, she is a good contact. What she can do: medication management. She does a suicide screening. She does a crisis intervention. So if you have acute cases of mental health, she is the person that you would be contacting. I did include handouts in the literature on page 341 and 342 that were given to me from her. She also does the coordination for the Community Services Board when the child leaves the detention home. So she can be a good contact and resource for you. So section 16.1-248.2 mandates that there are procedures in place to do a mental health determination for juveniles. In Norfolk specifically, they do an immediate mental health screening. It is a pretty basic screening. Ask just a couple questions and hits on, are they using alcohol or drugs? Are they angry or depressed? Suicide ideation. Again, they're just looking for acute cases, and that is just to make sure that everybody lives. It's really not a significant diagnostic tool. What other things that you can do if your child is in detention? You can ask the court to get a psychological evaluation on your child. A lot of times when we have kids that are not on Medicaid, their parents, for a variety of reasons, mostly poverty, are unable or unwilling to get the child any type of services prior to this situation. You can get a psychological evaluation. Do it early. Talk to the right people, try to get the funding. Don't delay in doing that. CSB, CSU, get all the people in your court to help facilitate that. The Norfolk Detention Home will not transport kids to their providers or mental health providers. In limited circumstances, I have had judges order that, but they're not really equipped to do that. So that is really, if you have an acutely an ill child, or a child, for example, that has one last appointment for their psychological, you can always ask the court to order transportation to that mental health provider. The detention is not going to prescribe medication. They're not going to make on-site diagnosis and make any sort of treatment plans. I will tell you that in terms of transportation being an issue, they also require that if a child has medication, the parent has to bring it there. That is a huge problem. In Norfolk, the detention home is on Military Highway. We don't want them picking up any new driving charges. So it's certainly difficult that they have to put that burden on the family, okay? And certainly we see problems with systemic mental health issues and families also having the problem, right? And so that makes it quite challenging for parents to do that. So that's kind of things you're dealing with detention. So get them out of detention. Detention alternatives, outreach detention, all those great reasons why you can resume services, resume continuity, have this holistic family approach, keep them in their comfortable environment, limit the trauma. In Norfolk, on page 343 of your handout, if you got one, talks about, we have one group home in Norfolk called Paramount. Unfortunately, we don't have a group home for girls. We only have one for young men. And so Paramount is the only option really for us if the child is not released to outreach with GPS or just outreach. Group homes, Paramount. Paramount offers a predispositional mental health program. I actually didn't know this, so I feel remiss in my abilities to advocate. I didn't know that. So it is a great opportunity, particularly when we have, as a public defender's office, sometimes we'll get appointed to a failure to appear charge, a class 1 misdemeanor, show cause, or the child didn't show up, and it's really based on a CHINS petition. So they're not criminal children, they're not really engaging in unlawful behavior, but the court wants to hold them because they're running away or because there's some family issue. So this predispositional program at Paramount, it does require a court order, and it can focus on family therapy. It can help with medication management, and we can order it and ask the court to order it right away. It can be as short as a month program. It can be as long as a year program. But if there's some reason the court is not letting the child out of detention, I think this is a good resource for us to ask for that. even if you're guardian ad litem and you're not the criminal attorney, I think that is also a good resource. So I know that there are other group homes in Hampton Roads and other programs that they have, but I would ask to see if they have predispositional mental health programs. I think that's important to know if you are practicing in these jurisdictions. So again, I think that the goal here is just to get your kid out. They're much better equipped to lessen the effects and the harmful traumatic experiences of the criminal process, much less, harsh effects onto them if you can get them out of detention and move them back home and get them services. So thank you. I'll turn it over to Judge Bullock, give the judicial perspective.
Oh, it's already on. Okay, good afternoon. It's a frustrating time to be on the bench when it comes to mental health issues in juveniles. And that's just the honest truth. Many kids that are brought before the court, it is exactly for what you've already heard. It may be a cry for help from the parents who cannot get it in the community. The juvenile justice system is not designed to deal with these issues right now. I'm pretty comfortable in saying that the justice system, the courts, are not equipped or designed to deal with these types of issues. Our court services unit in Virginia Beach and court services unit like juvenile probation and parole, they often can divert some cases, meaning you come in and it's a type of charge that may be nonviolent, and therefore they can work with the family and the child to perhaps have the charge never come before the bench and before a judge, and that's something specific with juveniles. But oftentimes, that is not the case if the parent goes and takes out a felony grand larceny charge because they're tired of their child stealing and they're just trying to get some help. And those kids can't be diverted. And so what do we do as judges? We enter orders, right? We tell everybody what to do. And often those orders and how we fashion those orders come from the evidence that we get in court and from counsel and from the witnesses. And oftentimes, that's the way we find out that there is a mental health issue, is from the attorneys. And once there's a mental health issue and if there's a trial, who do you think is the first person that gets subpoenaed? The therapist. All right? And you often wonder if you've been talking to this therapist for years or whatever about your issues, and now they're going to sit in court and tell the judge everything you've told them, what that does to that relationship. It puts everyone in a difficult situation. So then the judge will enter an order, and I'm going to order you to have in-home counseling, family therapy, individual therapy. You need to maybe get a job. You got to go to school every day. And parents, you got to do all that stuff too, and anything else that any other service provider recommends, substance abuse, therapy, treatment. Sometimes, where is the time? And I found myself as a judge ordering all these services and finding those people back on a probation violation in a criminal case or in a civil case, such as Ms. Cunningham case, finding them back maybe on a removal petition. And generally the general theme was, as a parent, I work from 8 to 5, just like all of you. The child has to be in school, and we're supposed to do all these different therapy appointments, before 8 o'clock at night and have dinner. And it just became impossible. And finally, the light bulb went off. And so now I think we do a good job in Virginia Beach of trying to prioritize services. Because if you just order it all, they're going to try and do it all, but it wouldn't be easy for many of us to do all the things that we're ordering. And again, like I said, transportation then becomes an issue, conflicting appointments. Most of these therapists are booked for a very long time. And so even getting them in becomes very difficult. And so oftentimes the attorney has to be the advocate for these young people. If you have a child, I'm going to just go over just a few issues that come up in court that you should be mindful of. If you have a child in a criminal proceeding and you request a competency evaluation be done, and maybe the Commonwealth can do it, the defense attorney can do it, the court can order a competency evaluation. If you represent the child as a guardian ad litem with that child's attorney, you should follow the timeline and make sure that an evaluator comes to see your child within the prescribed times or get that case back on the docket. I recently had a case, the juvenile sat in detention for 5 months. The case kept being continued because the child never got evaluated. There are statutes right on point that say when someone has to come and evaluate the child. If someone had let the court know, I could have done exactly what I did, was take a recess and go call the department in Richmond, and all of a sudden all these kids that were on a backlog, all their evaluations were done. But that should not have happened, especially if your client is in secure detention, because we've already heard, and I think what she said is very true about what happens, especially if the child has already been seeing a therapist. Now they're in secure detention. Most of those therapists aren't coming to secure detention to see them. They may not see anyone. And then when I order additional therapy, now they have to go see another therapist. And from what I know, I'm not a therapist, but I know that generally I need to build a relationship with someone before I just start disclosing, all this sensitive information. And so we have to start that rebuilding process all over again. Sometimes you find they have to change therapists because their insurance doesn't cover it. They had that Medicaid issue they talked about. They had a therapist when they were out of custody. They go in custody, Medicaid gets cut off. Now they're out of custody, and there's a delay in time, and now there's no insurance coverage to cover, so they can't go back to the same therapist that they had. Sometimes that's a good thing if they weren't getting anywhere, but other times, they need to keep that connection. So I'd say attorneys, you need to make sure that if you advocate for your client, and make sure they're not lingering, whether they're in custody or out of custody. If they have appointments, or if someone's supposed to be seeing them, you need to make sure that those appointments are done in a timely fashion, and not just always just agree to continue the case, because all that time, that child is not getting the help that they actually need. And then if you have a child that is found incompetent, the next thing the court would order is that they be restored. In a criminal case, they be restored. Sometimes what will happen is we'll come back to court on a court date. I'll have the letter from the therapist saying that the child has been restored to competency and now able to stand trial, but nobody's ready to go to trial. So now we continue the case, and now the child starts to decompensate. All right, and now we're right back to where we started, and now they have to go back and be restored. A lot of this seems like it could be avoided if you pay attention to the timelines and stay on top of it, advocating for your client, because the judicial system is not necessarily where you want it to be if they truly are a mental health situation. Over medication we often see, which I'm glad that Ms. McConnell had mentioned that. And I mean it in this sense. You'll have a juvenile that was placed on these medications at the age of 12, and here we are 17, they're still taking all those same 5-6 medications. They never went back to the doctor, or whoever they see may just keep prescribing those medications without really evaluating, do you still need them? I equate that, I go to the doctor, maybe I have a heart problem, diabetes, and a fever. They say, take Tylenol for the fever, and I just keep taking it for the next 10 years. All right, that wouldn't make sense. All right, but oftentimes we as the judge has to order, a medication, and the word just left me, when they go back and get reevaluated, medication, I think management appointment, in order for them to go back and be reevaluated again to say, do you still need to be on this medication? As I have all these charts of all these medications and what they do and should they be taken at the same time. I'm not a therapist, psychiatrist, that's not my area. But because trauma plays a big role nowadays, judges have had to be informed about how to identify certain issues and what to do with them. But like I said, the court's really not designed, if it's truly a mental health issue, to deal with that. And the other thing is with the other issue that the court has, lastly, that I'll say, is cooperation with service providers. You have a family who has Blue Cross Blue Shield, where they go to a private service provider, and that service provider says, yes, I will see you, I will treat you, I will do all these things, but I am not coming to court, and I'm not sending a letter saying how you're doing. That is no good to the court. We find that the only service providers are often the service providers who are responsive to the court are the ones who actually have a contract with the city, but then that remove some of the choices, because again, when I said that individuals have a connection with their therapist, but if it happens to be with a therapist who does not want to cooperate with the court, I don't have any other option but to order that they go see a therapist who will cooperate with the court, and meaning send a letter to give me an update. Are they are being treated for this? Are they getting better? Are they getting worse? Are there additional issues that we need to address? And so all these issues kind of culminate in the courtroom, and it makes it very difficult for the court, because sometimes I find myself being the judge, the mom, the dad, trying to figure out, we can't get there. How can we get them there? And all of this with no money. There's just not funding. There's not resources. And the first time we want to get a kid, where do we try and go get them at? The school. And Miss Lannetti says, leave the schools alone. Right? And so it does put us in a quandary. I am very hopeful and optimistic that we will be able to resolve some of these issues. I will tell you that because of the fact that most court services units divert young people who don't need to be before the court immediately, it's a fantastic thing, but it does mean that majority of the young people who come before the court really have serious issues to deal with. Sometimes I say, I just wish I had the kid that stole a piece of candy out of 7-Eleven. Just not those kind of cases anymore. So with that, I will leave some time for some questions. Thank you.
Is this on? I think that we are out of time, and let's give all of our panelists a big hand. This was very, very good discussion.